Hi, everyone. Welcome to our webinar today. We're going to be talking about the FAR Changes Clause, what it is, when it applies, and why it matters. My name is Leela Salim, and I'm with Fedmine. I'm happy to be joined today by Maria Panichelli of Obermayer. Next slide, please. Please use the Q&A box for questions as opposed to the chat box. We'll have time to answer any questions at the end of the webinar. The slides and the recording will be sent out to all registrants later this afternoon. Next slide, please. Founded in 2004, Fedmine is a business intelligence platform that analyzes and simplifies the increasingly complex federal business landscape in real time. We provide our clients the visibility they need into their addressable market of business opportunities. With Fedmine, you can receive twice daily alerts based on opportunities and contracts within your addressable market, build a pipeline of recompete and newly forecasted solicitations, dissect your competition, quickly view agency profiles, and much more. The beauty of Fedmine is that you can tailor it to any market. Next slide. We integrate from 17 different sources, and it's all done via our backend database technology. Some of our sources are FPDSNG, BetaSAM, USA Spending, GAO, VIP, GSA, and more. While our main clientele are government contractors, both large and small, prime and sub, anyone who has a need for federal spending and opportunity data can use Fedmine. This includes federal agencies, PTACs, and various other support organizations. Next slide, please. I'm pleased to formally introduce our speaker today. Maria Panichelli is a partner and the chair of the Government Contracting Practice Group at the law firm Obermayer, Rebmann, Maxwell, and Hippel. She focuses her practice exclusively on federal government contracting, with a particular emphasis on construction-related contracting issues and small business procurement. Maria helps clients navigate all stages of the federal procurement process. She blogs weekly about government contracting and small business procurement topics at GovCon Examiner and is a frequent lecturer at industry events. She's also a co-author of the best-selling government contracts book, Game Changers. This is our fourth joint webinar with Maria, and we're happy to have her back today to learn from her expertise and knowledge on this important topic. Maria, it's all yours.
Thank you so much, Leah, for hosting. And for anyone who wants to get in touch with Leila and with Fedmine, you can see that her contact information is up here. So what we're going to be talking about today is the FAR, Federal Acquisition Regulation Changes Clause, what it is, when it applies, and why it matters. As per the little introduction you just heard, my name is Maria Panichelli. I am the head of my firm's government contracting group, and that means I help clients through all stages of the federal procurement life cycle, which includes everything up from bid protests and both asserting and defending bid protests at the early stages of procurement, through what we call performance and compliance counseling, which is if an issue comes up, excuse me, while you're performing, and if you're trying to work that out with the government so that it doesn't turn into a bigger issue or dispute. We also help if unfortunately you're unable to avoid it turning into a bigger issue and a dispute. We help with REAs, which are requests for equitable adjustment, and claims, drafting, negotiation, litigation, settlement. Separate and apart from those things, we do a lot of performance and compliance counseling with regard to False Claims Act, Buy American Act, different federal procurement related statutes and regulations, including all of the small business regulations. So I help clients with things like certification and eligibility analyses and affiliation analyses, and of course the perennial favorite, teaming, joint ventures, and mentor protege. The last piece of our practice in my group is the subcontracting piece, which is, negotiating and drafting subcontracts that are FAR compliant, working on pass-through claims and liquidating agreements, Miller Act claims, and basically any issue or dispute that comes up between primes and subs. So as Layla said, if you've got questions during the presentation, you can feel free to ask them. I will try to either take them as they come in, or I can, leave some time at the end as well. If we've got questions either that come up later or that you've got but we don't get to today, my contact information is on the screen. You can feel free to reach out to me directly. You can also reach out to me on LinkedIn or on Twitter. You can see my contact information there on the screen. That's where I share when I'm doing events like this, when we post new blog articles, when my peers out there in the GovCon industry post any articles, and generally just whenever there's news relating to federal procurement or small business matters. So with that, I want to dive in and start talking about the meat of what we're talking about today. I mentioned in terms of my practice, two different areas that kind of dovetail with our topic today. The first is that performance and compliance counseling piece. And the idea there, again, is, if you understand the regulations properly, you know what you need to do during performance, and if any potentially problematic issues come up during performance, you know how to handle them and hopefully avoid a dispute. But the other piece of my practice that I mentioned is, the drafting and negotiation of REAs, requests for equitable adjustment, and claims. When you are seeking either additional time or additional money from the government in connection with an issue that came up, and you're either at the REA stage and hopefully negotiating to get that money or additional time added into the contract, or maybe you're at the claim stage where you're actually litigating because the government has decided that, at least on first attempt, they don't want to give you those additional days or dollars. So what we're going to be talking about today is the changes clause, and kind of the changes clause as it spreads across those two areas of my practice. And by that, I mean, what we're going to be covering is, okay, if you're on a contract and you're performing and a change occurs, what do you need to do to make sure that you're compliant with the regs and that you're doing everything you need to do to hopefully work out with the government? Hey, we want some extra days, we want some extra dollars added into this contract because of this change. And to hopefully, everyone can agree to get the days and dollars added in through a modification and you can all go home. But what we're also going to talk about kind of woven through there is what happens if the government doesn't agree with you that there are days and dollars due. What do you need to do to make sure you checked all of the boxes and that you covered all of your bases, so that if you have to do an REA or a claim, specifically if you have to go down the claim route and then litigate that claim, what do you need to do to make sure that your claim is as defensible as possible and that it's not going to be defeated on a procedural issue? So that's kind of the focus of what we're going to be talking about today, the changes clause, so that you can understand it, recognize when changes occur, and do what you need to do to be compliant under the FAR, while simultaneously doing what you need to do to protect your right to claim additional days and dollars and get properly compensated for your performance on the contract. So the biggest thing is we're going to start talking about is recognizing the issue. Recognizing when there's a change. And, change is a pretty simple word. Most people probably know it. But there's a little bit of a wrinkle in the federal government context, which we're going to talk about in just a second. This all starts with, like everything in government contracting, it depends on what's in your contract, right? So you need to go to your contract and see the changes clause that you've got. There are several different versions of the changes clause that are in the FAR, and depending on what type of contract you have, there's going to be one of the versions inserted in there. We're going to be talking today using the example of the changes clause that's the last one, 232-4, just because that's the most common clause. I'm sorry, 243-4, just because that's the most common one that you see in contracts for the government, and the one where most of the cases arise under. So most federal contracts are going to have some version of the changes clause. There are very limited exceptions, like some OTAs and things like that. But generally speaking, as a default rule, you should assume that a changes clause is in your contract. Again, check which one you have and make sure you understand the requirements of the specific contract clause in your contract. But there's going to be one in there. And frankly, even if there isn't a changes clause in there, there's a doctrine called the Christian doctrine that the courts have kind of developed. And the idea of that doctrine is that even if there are, well, with regard to the most important seminal fundamental FAR clauses, the court is going to basically take the opinion that even if the government forgot to cut and paste it into your particular contract, they probably meant to, because it's such an important clause. The courts are gonna read it into the contract as if it's there anyway. So all that to say that you've got a version of the changes clause in your contract almost certainly. And even if you don't, it's probably read in through the Christian doctrine. So again, be aware there's several different versions. Check your contract to make sure which version you have, and then you're off to the races. So let's talk now about changes and the definition of changes, and kind of what I referred to before as the wrinkle in the way that you interpret the word change in the context of a federal government contract. So the way that the regulation is set up, there are two different kinds of changes. There's an express change, which is one that is either requested by the contracting officer, often through a request for proposal, or maybe issued through a modification, which obviously on its face, it's a modification to the contract. It's obviously an admitted change. But there is also, and I should say the express ones are usually pretty easy to spot. Contractors rarely miss those or rarely fail to approve.
Maria, I think we can't hear you. We lost your audio. Oh, it says she's reconnecting. Everyone stand by 1 second.
Hello, can everyone hear me? Can somebody?
Yes.
I got kicked off my phone call, so trying to connect through computer, but want to make sure that everyone can hear me.
Yes, you're back. Thank you.
All right, so I'm not sure where that cut me off, but what I was saying is there's two types of changes. The first is an express change. Those are the ones that contractors are usually, pretty easily able to spot. The sneaky ones are the constructive changes, and that's where the contracting officer basically either through impliedly ordering a change kind of triggers the changes clause. That can happen whether they issue a direction that's maybe, at least in your interpretation, outside the scope of the contract, or if there is a change in the interpretation of contract terms. And we're going to talk about some examples in just a little bit. But that's the one that you need to watch out for, because that's the one that a lot of contractors don't understand when it happens that it constitutes a change, and therefore they don't understand what they need to do to cover their basis once it happens. So let's go back to the clause. Again, we're using the version that's at 243-4 because that's the most common version, in my experience with most government contracts. What it says is that the contracting officer may, at any time, without notice to the sureties, if there are any, by written order designated or indicated to be a change order, so in other words, a modification, make changes to the work within the general scope of the contract. So a couple things to take out of this clause. This is the part of the clause, section A, that's talking about express changes. It's, talking about a written order that is on its face clearly indicating that it's a change, a modification to the contract. Notice that it also says that the contracting officer has wide discretion to make any number of types of changes in the specs, the drawings, the designs, the method or manner of performance, the government furnished property or services, potentially directing acceleration in the work. But notice that above that, it kind of limits that it still has to be within the general scope of the contract. There's this idea that at some point, a change that fundamentally alters the whole nature of the contract is a material or cardinal change, such that, maybe it doesn't fall within this clause. But unlike in a lot of private contracts, cardinal change is a pretty rare thing in government contracting. Usually government contracting officers have a huge amount of discretion in ordering these changes. But again, A talks about express changes, when you specifically have a written order that's saying, hey, we're changing the contract, or we're thinking of changing the contract. So let's take an example of an express change. In this example, there was a contract from one of our clients called for the construction of a one-story building as part of a base construction project. During construction, the end user, the ultimate agency, pointed out that the building needed much more office space and really needed to be 2 stories. So just before the foundations were laid, the government issued a request for proposal to the contractor to change the building to a 2-story structure. This resulted in a modification. Again, an express directive showing that, hey, we're making a change to the contract. Pretty clear, right? So those are express changes. That's the easy part. What about constructive changes? Those are the sneaky ones. What's the part of the clause that deals with that? And it comes in section B. And section B says that if there's any other written or oral order, that is going to be treated as a change order if it causes a change. So in other words, what that means, and I've used this example before, but in kind of common parlance or idiosyncratic speak, I guess, idioms. If it looks like a duck and quacks like a duck, et cetera, et cetera. Okay, fine. The contracting officer isn't calling this a change. Okay, fine. The contracting officer is saying that this is part of the scope, and I don't, or maybe they're expressly telling you that they don't think it's a change. If you think it's a change, and that can include things like direction, instruction, interpretation, or determination. And we're going to look at examples of that in just a second. That is a change, or at least it, arguably is a change, and you need to be looking into or perhaps discussing with a specific legal professional whether or not it falls within this clause. I did see that we have a question come in about not accepting the change. We're going to talk about that a little bit later. So just hold on, and we'll talk about your right to, or your obligation to continue to prosecute the work. So like I said, a lot of contractors fail to appreciate when a change like this occurs. So let's take a couple examples. This is an example where there was a change to the means and methods of the performance. Client of mine had a contract that was part construction, but then large part integrating the online security systems of the new renovation that they had done. So there's a lot of back end kind of IT and security and cybersecurity, or not cybersecurity, but IT system and security server type of work. The contract allowed the contractor to perform the software updates, a lot of the the online portions of the work remotely, which makes sense, right? It's all computer coding work. The new personnel that took control in the government, the new contracting officer, however, said, no, I'm sorry, I don't want to allow that anymore. I'm not going to allow you access to the government network. I'm going to shut down the security protocols. You're not going to be able to do any work remotely. So basically, they refused to grant my client remote access. So my client had 2 choices. They either had to employ a local subcontractor to do the work, since it had to be done in person, or they were going to have to schlep all of their people, 3 states over, pay for their travel, pay for their per diem, pay for their hotel costs while they put them up for 6 months to finish this work. Either way, obviously that is not an expense they were planning on incurring based on their original interpretation under the contract allowing for remote work. So there, government didn't call it a change, didn't issue a mod, but they changed the means and methods, and it resulted in my client incurring additional costs. That is a constructive change under Section B. Let's take a look at another example. This has more to do with the interpretation of a contract. This was a contract for one of my colleagues' clients. Contract required a certain amount of electrical outlets per square meter of office space. Contractor interpreted this to require, X amount of outlets per square meter of office space across the entire building, averaged out. Government personnel, however, was like, no, that's not the way I interpret it. I interpret it as so many outlets per square meter per office space. And then if it's an unround number, you got to round that up further. So it doesn't sound like it would make that big of a difference, but it did. It was a large amount of space, made a huge difference, resulted in the installation of many more outlets. That is, even though the government didn't call it a change, even though the contracting officer didn't say I'm issuing a mod, that is a constructive change. It's a change to the interpretation of the contract. So why are we spending so much time on, what a change is and what type of change it is? So usually, we're going back to what I said at the beginning, the reason that you're keeping track of this, right, is so that you can try to work out with the government, hey, because of the change to the contract, I need some additional days. I need some additional dollars. This required additional work and it cost me additional money. If you want to get those additional days and dollars, if you want to be able to request an equitable adjustment or request a mod, or ultimately if you have to file a claim, you're going to need to show that you fulfilled your notice requirements. And the notice requirements differ depending on whether you're dealing with an express change or a constructive change. So when you are dealing with constructive changes, we're going to go back to the section of the clause dealing with constructive changes. That's B. Remember, it's up on the screen. And you've seen that first part of the clause before, right? Any other written or oral order, which includes direction, instruction, et cetera, shall be treated as a change order under this clause. But here's the part that we're going to talk about now, provided that the contractor gives the contracting officer written notice. So in other words, yes, we're going to treat something that the government didn't call a change, but that functioned like a change. We're going to treat that as a change if you, the contractor, provided notice to the contracting officer. And what does that notice have to say? It has to give the date, circumstances, and source of the order that you view as the change. So in other words, when you got notice from the government that you weren't allowed to work remotely anymore, when you got notice from the government in terms of their interpretation of the, how many outlets you had to install, you need to then say, on this date, I got, an email from the contracting officer, or the contracting officer told me, whatever they told you that you consider to be a change. And I regard that as a change to the contract, and I reserve my rights to, request additional time and money under applicable law and equity, or whatever you choose to put in your form letters. But you need to provide notice when there is a constructive change. And the point is to kind of have everyone on the same page. In general, when you're talking about, express or implied or constructive changes, you also need to do a general cost proposal. And you need to do that within 30 days after. If it's an express change, you get a receipt for a written change order. And if it's a constructive change, you give the notice that you give. So notice regarding changes, costs, the cost proposal. What kind of costs or damages are you talking about when you're talking about a change? Well, generally, you're talking about if there's any direct costs to perform the changed work, especially if there's additional work. So things like additional labor costs, additional material costs, additional equipment cost, especially like if you're renting certain equipment, subcontractor costs, and then you get to mark up your subcontractor costs too, to kind of depending on what your contract says. There might also be impact on unchanged work that might be either days or dollars. And then depending on, the particular situation, you might be able to add overhead and profit in on top of that as well. I do want to talk about some quick common mistakes and misconceptions about notice. We're going to do that by kind of answering some hypothetical questions. So let's say the government issues an RFP. In other words, a request for proposal they're thinking about making, but they have not yet made a change to the contract. And most likely, if they're doing an RFP, it would be, they'd ultimately issue a mod. There'd be an express change to the contract. So are you if the government issues an RFP, are you required to say, hey, this is a change to the contract? Do you need to give notice there? No, you don't. Because again, it's only at the RFP stage. They haven't issued a mod yet. If after you submit your response to the RFP, the government says, yep, looks good, we're going to issue a mod, we're going to do an express change to the contract, even then, you wouldn't have to give notice that you consider it a change, because that type of notice is only required when it's a constructive change. Remember, this would be an express change. Now, the reason for that is obviously the government is calling it a mod. They're issuing a modification. They're admitting it's a change. You don't need to give notice you consider it a change. They already consider it a change. Everyone's on the same page. So no notice required either at the RFP stage, because there's no change yet. There's just a proposed, we're thinking about a change, or at an actual modification period, because everyone admits it's a change. Now, again, remember that you might need to, at the modification express change period, put together a cost proposal if you don't think you got paid sufficiently. So, you might still have to keep track of that 30-day period in that case, but no notice requirements per se. What about if the contracting officer directs additional work? They don't call it a change, but they're directing you to do something that isn't consistent with your interpretation of the contract. Now, remember, which category does that fall under? That would be a constructive change, right? So under constructive changes, section B of the clause, yes, you would need to provide notice saying the date and circumstances and the source of the instruction or the direction that you thought is a change to the contract, that you think it's a change to the contract, and that you reserve your rights to seek additional days and dollars. What about if you believe the contracting officer's interpretation of the contract would require you to perform additional work or constitute a change? Again, that's another situation where it's a contracting officer's interpretation. They haven't issued an express change, but they have impliedly or constructively changed the contract. That's a constructive change under section B, and yes, you would need to provide notice. So let's talk a little bit about performance of the work, and circle back to the question that I saw pop up a little bit earlier as well. What if the government issues an RFP, a request for a proposal that says, let's use the example from the beginning of the slideshow. We're thinking about expanding this construction. Instead of it being a 1-story building, we want it to be a 2-story building. Maybe the government's going to issue you an RFP and say, how much would it cost you and how much time would it take you, if you were going to change the contract in that way. And you get back to them and you say, 2 extra years and $1 million extra. When the government issues an RFP, are you supposed to proceed with that work? Are you supposed to start building up that 2nd story? No. Again, remember, the RFP is just the government's idea of being like, hey, we need to suss out what it would cost and how long it would take. And if we feel like actually making this change, we're just kind of thinking about it. We're browsing right now. We're not ready to buy. So no, your contract remains what your contract was, unless and until there's actually a change made to the contract. So an RFP is not a change yet. So you don't want to assume that that's been incorporated into your contract. You want to wait for the actual modification. What about if the government issues an RFP? And again, let's use the example, they're thinking about doing a 2-story building instead of a 1-story building. Are you supposed to just stop and wait for them to decide if they want to issue a change? No, absolutely not. What happens then is you'd be blamed for the delay. So, unless and until they issue a mod or give you a direction that constitutes a constructive change that tells you to do, outside of work outside of the scope of your contract, you proceed with your contract as written. Now, the smart play is if you're getting to a point where you're like, all right, I've kind of reached the point of no return where I either need to start putting the roof on or we need to start building the walls up another story high. What you're probably going to want to do is send, or obviously that's just one example in the construction context. But if you've built a certain part of the network out and you're like, okay, I'm either going to have to, stop now and get all the security protocols in place and, kind of patch it all up, or I'm going to have to continue with, an additional year of coding or an additional year of, whatever. That's probably when you're going to want to reach out to the government and say, hey, just so you asked me a couple months ago for a response to an RFP. Are you still thinking of changing this contract? Because I'm at the point where I need to go down one route or the other. If you don't give me a change, I'm going to go down the route that was originally in my contract. And if you change it later, it's going to cost more money. It's going to take more time. So again, if you're in that situation, pays to talk to a legal professional to make sure that you're dealing with everything. But the key to take away here is an RFP is not a change. Wait till you get the change. This is going to circle back to the questions I got earlier about, what you can do in terms of refusing a change. Quick answer in response to the question I got: no. If the contracting officer changes the contract, you can't refuse to perform the change unless, going back to something I said earlier, it's a cardinal change, which is very, 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 very rare in terms of government contracting. When the contracting officer issues a change to the contract, you need to perform whatever they told you to do. If it's an express change, you need to follow whatever the mod, did to change your contract. If you think you didn't get enough time or money as a result, you need to file, a cost proposal and say, I want more time and more money. And then you need to litigate it from there. But yes, one of the drawbacks of doing business with the federal government is that you might need to self-finance work that's a change and continue to do that work while you argue with the government about how much money or time they owe you for it. That, specifically or especially can be true in the constructive change contract, where sometimes the government's not admitting that it's a change. They're saying, no, my interpretation is this is within the scope of your contract. And you're saying, no, my interpretation is that it's not within the scope of my contract. The only thing you can do in that scenario is cover your basis, give the notice that we required, and then you file your REA or you file your claim. And while you're litigating with the government and arguing about whether or not you're supposed to get additional time or money, you are legally required to continue prosecuting. In other words, continue performing the work. You are not allowed to say, I'm not performing until we work this out, until you admit it's a change, until you agree to give me extra time or money. You need to keep doing the work on the side or on the back end, argue about the days and the dollars, and make sure that in the meantime, you don't sign anything waiving your rights, which we're going to talk about a little bit later. So when the contracting officer interprets the contract and tells you, hey, I'm interpreting the contract this way, this is what you need to do. Is that a direction to proceed with the work that you must obey? Yes, you want to give notice saying that it's a constructive change so that everyone's on the same page, but you're not allowed to say, hey, I don't agree that I have to do that because that's not in my original contract, so I'm not going to do it. If you do that, you're going to get terminated for default. So it's a big red flag, a big danger area. Same thing, if the contracting officer directs additional work or interprets the contract in such a way that requires you to expend additional money, do additional work, do you need to proceed with the work? Yes, you do. Can you refuse to proceed until you get a mod or until you get payment? No, absolutely not. You do need to give notice that it's a constructive change, or if it's an express change, you need to give notice that you didn't get paid enough under the mod. And you need to, like I said, make sure that you don't sign any waiver language in a modification that says that, you're waiving your right to be paid additional time, or I'm sorry, to be paid or to get additional time on your contract later. So this all comes from the clauses, again, that are in your contract. And you need to look at your contract specifically and see, what it says about prosecution of the work. But most contracts, if not all, and again, this is another one of those Christian doctrine things, have the disputes clause, which is at 52-233, and it states specifically that the contractor shall proceed diligently with the performance of this contract pending final resolution of any request for relief, claim, appeal, or action arising under the contract, and comply with any decision of the contracting officer. So you need to continue doing the work and worry about arguing it on a side track, parallel track, or on the back end once you're done. If you refuse to proceed, or if you refuse to proceed without payment, you absolutely are in danger of being terminated for default. So like I said, consequences of refusing to perform as directed. And this is another one that a lot of contractors are just not aware of, especially if they've done work in the private sphere or even some state and local governments. They're just not as strict about this as the federal government is. But, if you cause a delay, that's not delay you're going to be able to claim for. That's pretty obvious. What's less obvious to contractors is if you're causing this kind of delay while the government is simultaneously causing another delay that you otherwise would have been able to get money for, and you otherwise would have been able to get a contract extension for, it's going to turn into uncompensated delay. It's going to cancel each other out as concurrent delay, and you're going to lose the right to go after all that money. You're probably going to, like I said, face termination for default, which means you're going to get cure notices or letters of concern that you're going to have to spend time responding to. And then if it goes the distance and you go all the way to T for D, those of you who are aware, that means you've got a negative mark on your record. It can affect your past performance. If you've got a surety involved and they come in, they can, there can be some pretty serious financial consequences for termination for default in terms of the government coming after you for reprocurement costs. Even if you have a surety involved and they go after the surety for reprocurement costs, the surety might then come after you to indemnify them if you've got an indemnification agreement. A lot of times that's worse because you probably personally indemnified things if you're an owner of a small business. Excuse me. So you really need to make sure that you're careful about this. So I want to kind of stress that all of this is kind of, you want to make sure that you are keeping the lines of communication open. So the idea with all of these notice provisions, even though it's kind of the first step in litigation, even though it's the box you need to check to protect your rights, if you're going to ultimately end up having to file an REA or a claim and, kind of argue about getting the money and time you're entitled to, you shouldn't look at the notice or any of the correspondence relating to these issues as, the place to start getting combative. you should look at it as the purpose of these notice provisions is to make sure everyone's on the same page. And again, the reason for that is the rationale behind these regulations is that if an issue comes up and maybe a contracting officer doesn't know that you interpreted a contract a certain way, or doesn't know that you planned your whole performance around the fact that you've got people working remotely, or doesn't know that you planned your whole performance about the fact that you were starting at a certain time on a certain day. And if you say, hey, look, Mr. or Mrs. Contracting Officer, I'm totally cool doing things the way you want. But just so you know, that's not the way I was originally planning on doing it. If I do it your way, it's going to cost me, an extra $1 million and take an extra 2 years. You sure you want me to proceed? I'm happy to, but just want to let you know, if we're going to go that route, I consider it a change, and I'm going to seek additional days and additional dollars on my contract. The contracting officers might say, oh, wait, no, I I definitely don't want this to take an extra 2 years or cost $1 million. I didn't realize that that's the way you were looking at it. And they might say, can we do it this way? And you say, yeah, that'll cost an extra $5 and take an extra 5 minutes. And they might say, all right, great, then let's do it that way. They might say, no, you know what? I need what I said I need, so you're going to have to do it. Or they might just say, never mind, let's do it the way that you were originally planning on doing it. Now, I don't want to get your hopes up. A lot of times you give notice and the government says, yeah, that's fine, do what I told you to do. But the purpose is that, you might be able to avoid a large dispute and you incurring a lot of damages, and the government later having to pay you back for those damages, or a portion of those damages, if you're just all on the same page about the fact that there are going to be additional costs and damages. The idea is maybe if you give the government a heads up on that, they're not always going to want to continue with the road they were going down. So honest and courteous communication about a specific change or a potential change as soon as it comes up is really best practices. The contract governs, right? The contract scope is what governs all of this. So a lot of times if you just are like, hey, based on what you just told me, you're interpreting the contract this way, I interpreted it this other way, so this is going to be a change, let's talk about it. That's, a way to avoid a dispute. Sit down and talk about the contract together. The government might not realize that it's directing work that is, at least in your view, not required by a change. Is not required by the contract and then constitutes a change. All right, slides, come on. There we go. So the other thing I want to kind of make clear is that the changes clause doesn't just relate to changes in the context that we, have talked about so far. You might have heard the term defective specifications, or if you're in construction, maybe defective drawings or defective design. You also obviously have heard of delay claims or delay issues. In a lot of cases, defective specifications are always under the changes clause. Delays, if the cause of the delay or the thing that led to the delay, if the delay is arising out of a change, then your delay claim, quote unquote, is really a part of your changes claim too. So even if you're not going to have additional money, additional damages as a result of a change, if you're just going to have additional delay, all of the stuff that we just talked about applies. You need to give notice and you need to kind of preserve your rights to be able to get an equitable adjustment of those days, even if there's no dollars tied up with those days. It's rare that there's no dollars tied up with the change, and there's rare that there would be no dollars tied up with the days themselves. But sometimes you're just going to want the days and not the dollars. And all of that applies. All of what we talked about applies as well. There are, delay claims that if they arise out of changes are technically under the changes clause, and therefore everything we talked about, applies, and all the notice requirements that we talked about applies. So the other kind of caveat or asterisk that I want to add to this is that you need to be aware of something called authority. Only contracting officers have the authority to change a contract. So if somebody else, like a COR, a contracting officer's representative, or if you work with the VA, a COTR, KOTOR, as a lot of people call them, tries to make changes to the contract, they don't have the authority to do so. FAR 43102 kind of outlines the authority that a contracting officer has, and it says that COs acting within the scope of their authority are empowered to execute contract modifications on behalf of the government. But it specifically says other government personnel shall not execute contract modifications or act in such a manner as to cause the contractor to believe that they have authority to bind the government, or direct or encourage the contractor to perform work that should be the subject of a contract modification. So in other words, all of that stuff we talked about with constructive changes, all of the idea that, we're going to assume that, even though they didn't put it in writing, even though they didn't call it a change, as long as you give them notice that you thought it was a change, if all of that stuff happened, we're going to treat it like a change. What this is basically saying is, yeah, if it came from the contracting officer, if it came from everyone else, you can't assume that because they didn't have the authority to change the contract in the first place. So nothing they said should have told you, oh, yeah, I should assume that this is a change to the contract and I'm going to go ahead with whatever they just changed. They don't have the authority to do it. Only the contracting officer has the authority to do it. And again, specifically where you see this come up the most, at least in my practice, is with the CORs, the contracting officers representatives. Maybe you've got a pretty absent CO and your point of contact and your regular person that you're going back and forth with is the COR or the COTR. They do not have the authority to make any commitments or changes that affect price, quality, quantity, delivery, or any other terms and conditions of the contract, nor in any way do they have the authority to direct the contractor or your subcontractors to operate in conflict with or outside of the scope of the contract terms and conditions. So they cannot be delegated responsibility to perform functions above their level. They can't have the level of the CO. They can be assigned some duties, but they do not have the authority to issue these kinds of changes. So what does that mean for you? It means that if you're getting a direction from a COR that is kind of telling you to do something outside the scope of the contract, any of the examples we talked about before, a means and methods change, a change in the interpretation of the contract, anything that you're like, well, I think that's a constructive change, they don't have the authority to do that. So if you were to go ahead and be like, all right, well, he told me he's interpreting the contract this way, I gave my notice, and now I'm going to go ahead and do the contract that way. And then, you wait 6 months and you file a claim letter and say, there was a constructive change. The COR told me to do this. I did it. It cost me $500,000 and took me 2 months. The government's going to come back and say, yeah, the COR didn't have the authority to change the contract and you should have known that. So there was no change to the contract. Sorry, you're done. You're not getting those days or your dollars. So you need to be very careful about who is giving the direction or the interpretation. Let's take a look at an example. So 2 government design reviewers, design build construction project, requested additional features be included in the design that significantly increased the construction costs. Contractor notified the contracting officer of one of the design reviewer comments, and the CO authorized the change. However, the contracting officer failed to notify the CO of the other reviewer's comments and proceeded with the work. So let's break that down. There were 2 constructive changes ordered by 2 design reviewers. So neither of them are contracting officers, right? Neither of them have the authority to change the contract. So what the contractor did with regard to one of them was, I'm going to show it to the contracting officer. I'm going to run it up the chain of command. And the contracting officer said, yes, I bless this. So now you do have direction from the contracting officer, somebody with authority to proceed with that work. Albeit they didn't call it a mod, but it's a change to the contract that the contracting officer just authorized you to go ahead with. So now someone with authority has told you to do it. But with regard to the other one, they didn't run it up the flagpole. Contracting officer didn't know anything about it. So when they went ahead with that work, it was a completely different situation. So later, when the contractor tried to recover, what do you think happened? They were able to recover under the changes clause for the change that the contracting officer had signed off on, had ratified, had blessed, but not the one that they hadn't ran up the flagpole to the contracting officer. So what does this tell you? It tells you that if you've got a situation with an incredibly absent CO and you're dealing with the COR, and the COR does something that, would be a change to the contract, the practical reality is you're not going to be able to just ignore that and say, well, I'm sorry, you don't have the authority, so I'm going to go back and sit on my trailer. Obviously not going to work. So what you need to do then is you need to send a letter to the contracting officer. You need to make sure you include everything that you would have included in a notice, the date and the circumstances and the source of the order that you consider to be a change. But you also need to specifically say, hey, I know that this person doesn't have the authority. I know that you do. Do you agree that I should go ahead with this work or not? Ideally, they get back to you and either they say yes or they say no. If they say no, you're off the hook. You don't have to do it. If they say yes, now you've got someone with authority telling you to proceed. If you get no response, that's really a time that you should be working with your lawyer to make sure, that you're covering your bases in all ways, because absent COs are very problematic in a lot of different, ways. But what you ideally want to do is then send a follow-up letter and say, unless I hear differently from you, I'm assuming you're ratifying that change, and I'm going to go ahead with it, and I'm going to claim on the back end. Still not, airtight, but it's about as good as you can get if the contracting officer is just completely not responsive. And you've now put it in their court that, I'm basically assuming that you approve this and are directing me to proceed with what your COR told me to do, which is going to be a constructive change to the contract, which is going to mean you're responsible for paying me and giving me additional time. What do you want me to do about it? So that's what you need to do if you've got an issue with authority. Now, there are some exceptions to the authority rule. Yes, there can be something called implied authority. That's when maybe someone who doesn't have authority kind of acts enough like they do in order to kind of mislead the contractor and give them the impression they have the authority. However, if the contract specifically states that the contracting officer has the authority, it's only the only person that has the authority to change the contract, your implied authority argument's not going to work. And then ratification is what we just talked about, when you can say, hey, look, the contracting officer knew about this and was okay with it. But you never want to be in a position to have to either argue these, let alone prove them. If you don't have a letter, you never want to be like, oh yeah, I had a phone conversation with the contracting officer where they were like, do everything that my COR says. Because what happens is, if you file an REA, they'll deny it. If you file a claim, they'll deny it. 6 months or maybe not 6 years, but 6 months or 2 years into litigating and paying someone like me a whole lot of money to argue about it, you might ultimately be able to show, hey, look, the right person had authority and therefore I'm entitled to money. But wouldn't it be much easier if you were just able to attach a letter, to your first thing showing that you got the right notice, did the right notice and got the right authority? You really never want to have to litigate these issues. It's a lot easier for you to get paid and to get an extension of the contract date if you just deal with it up front. So the next thing I want to talk about is modifications, and specifically release language in modifications. And I've kind of implied or alluded to this a little bit earlier. But the idea here is that a lot of times in modifications that are issued, there is some release language, and it's usually in the place that they call the closing statement. Not always, but vast majority of the time, it's going to be in the closing statement. And it's going to say something along the lines of, this constitutes full and complete compensation. And depending on the wording, what it's basically going to say is this is everything the contractor is entitled to with regard to either, the issue at issue in this mod. That's the first or the second bullet point here, where it's kind of like, we're releasing everything. The contractor is releasing every claim that it could possibly have with relation to whatever the subject of this mod is. Or sometimes it's even broader than that, and it's like the contractor releases all claims up to this date on the contract. You got to be very, very careful not to sign either of those unless you agree that you have no outstanding claims on the matter. Here's an example of closing statement from a modification. And the key is kind of starts here in the middle, where it says it further understood and agreed that this adjustment constitutes compensation in full on behalf of the contractor and its subcontractors and suppliers for all costs and markups directly or indirectly attributable for the change ordered, for all delays related thereto, and for all extended overhead costs, and for performance of the change within the time frame stated. In other words, I'm getting whatever I got in this mod, and I will never ask for additional days or additional dollars ever again. Speak now or forever hold your peace. So if you sign a mod with this type of language in it, you've just waived your right to go after any more dollars or any more days associated with whatever the subject of the mod is. So this comes up, sometimes if you get an express modification or, express change in the form of a modification, I should say. And you're like, all right, yeah, we agreed that, you were going to issue a mod, but I asked for $1 million and you're giving me 200,000, and I asked for a month and you're giving me a day. No, that's not enough. That's not what I need for this change. You need to make sure you don't sign a mod that's got that kind of waiver language in it, or that's all you're getting. Another time that it comes up is sometimes, you tell the government, hey, that this issue has, this issue's come up, and the government goes, oh, I totally understand. How much time do you need? 3 months? Okay, great. we'll give you a mod for 3 months. We don't have the funding right now, but we're going to get it later, and then we'll issue another mod. But in the meantime, here's your mod for the 3 months. And then you go to the closing statement and it's got that language. If you sign it, you're not getting the money later, or at least, the government could argue that you waived your right to the money later. I'm not even saying they do it on purpose. I'm not saying that they do it to trip you up. I think a lot of times it's standard language that they include because their supervisors tell them to include it on every mod. I think sometimes it's a cut and paste error that they forget to remove it. But you need to be really on top of it and make sure you take a look, because if you sign away your rights, you signed away your rights. The boards and the Court of Federal Claims really, really don't like discounting waivers. They will hold these to be enforceable, and you will have limited your rights. So what options do you have in terms of, dealing with this? Well, the first thing is you can say issue this mod as a unilateral mod, not a bilateral mod. I don't have to sign it if it's a bilateral or if it's a unilateral mod. If they refuse to do that, you can say, okay, well, you need to alter the modification language, we need to alter the closing statement language in the modification and say, no, it's not a full and complete compensation. And you need to carve that language out and work with your lawyer to propose changed language that will allow you to assert the claims that you still think you have. If they still, refuse to do that, it's, again, you kind of got to decide what risk you want to run, in terms of what else is going on in the contract, if there's potential delay or LD's issues, or, your current relationship with that contracting officer. So talk about that with your lawyer, but there are a couple options, that include crossing the waiver out, specifically noting that you're signing the mod, but under objection, and that you don't agree to the waiver, attaching something to the mod when you send it in saying, I don't agree to the waiver language, but I'm signing the modification. None of those are airtight. Like I said, they're not perfect. So you're going to want to talk to your lawyer about those options when you're dealing with if they won't issue it unilaterally, if they won't issue it without the closing statement, if they won't modify the closing statement. Those are kind of like, ask 1, ask 2, ask 3. If they won't do any of that, you've got to get into a situation where you decide that, you're signing the mod, but you're taking some risk, but you're crossing out the mod language or what have you. That's a conversation to have with your lawyer. The other thing that you can do is kind of focus on, okay, what can you do to rebut this kind of defense at a later litigation stage? You can try to prove that the modification was issued, that it was unclear, that the waiver language is unclear, that, that anything that came after that date, you should be allowed to, claim for. That's usually successful. That it's outside, whatever you're claiming for is outside the scope of an earlier waiver. That's usually successful if true. There's also an argument that you can make in terms of, if there's any evidence later in the relationship between the parties that the parties didn't intend for something to be a waiver. For example, I had one case where there was a bunch of correspondence later that the government was about to issue another $500,000 modification. Obviously, the government didn't think that the contractor had waived their right to get additional money if they were about to give them an extra $500,000. So that's kind of, behavior of the parties afterwards that would indicate that they didn't intend the release to be a release. But these are all things kind of like with authority. You don't want to have to be litigating that back and forth. It really pays, stitch in time saves 9 kind of situation where it really pays to just be vigilant about what you do with the modifications up front. So as a summary, refuse to sign the bilateral modification. Ask that they issue it unilaterally, which would not require you to sign it, which means you're not waiving anything. If they don't do that, ask if they'll take the release language out of the modification. If they won't do that, see if you can agree on a modification of the language used. If they won't do that, again, that's when you definitely want to be talking to a lawyer, but some options might include, depending on your factual circumstances, crossing out the release, specifically reserving your claims, writing the reservation on the modification form itself, et cetera, et cetera. But, take every step you can to, preserve your rights. So quick wrap up with question, comments, and mistakes relating to modifications. Are you required to sign a bilateral modification? Yes, which is why you want to be very careful about signing one with waiver language. Ask them if they will issue it unilaterally. You are not required to sign a unilateral mod. If they refuse to issue it unilaterally, and basically you're at an impasse in terms of, if I don't sign this bilateral mod, there's going to be all these other problems. It's holding up performance. That's when you want to talk to your lawyer about, how do you still preserve your rights in terms of a reservation of rights letter, crossing out the language. And frankly, that's going to be really dependent on factual circumstances, really dependent on the case law as it sits at that time. There's constantly cases dealing with this issue, and the issue can get a little bit thorny. So, all right. With that, we've got a couple minutes left. I will open it up to questions. I'm going to go back through. I saw a couple questions come in on the Q&A box. So if I haven't already answered them, I'll get to them in just a second. But like I said, if you've got questions we don't get to today in the next few minutes, or if you've got questions that pop up later, you can feel free to reach out to me directly. You've got all my information there on the screen. All right, so questions. First one was, I think, the one that I covered before, but just to summarize, question was, could we not accept the change? Could the contracting officer cancel the contract as a result? Like I said, no, you don't really have the ability to refuse to accept a change. Your job is to make sure you give the appropriate notice, prosecute the work, and then try to get the days and the dollars on the back end. I'm assuming this refers to, it says for section B. So I think what the question asker is asking is with regard to implied changes or constructive changes. Could we request in writing as mod? You can, and that's a smart thing to do. They won't often do it, but what you can say is, I need direction in writing to proceed with the work. And I would like a mod. Usually they're not going to want to issue a mod because sometimes they don't agree that it actually is a change. And that's okay, because you're protected under section B. Obviously, yes, it's better to have a mod, but then you potentially run into all the issues we just talked about in terms of the waiver language. So, as long as you're providing the appropriate notice to cover your basis, and as long as you're tracking your costs, you should be good. Isn't it true that on a bilateral mod, contractor can refuse the change? On a bilateral mod, you can refuse to sign it, like I was just saying in regards to the waiver language. But the problem with that is, there might be other consequences. Usually there's a reason for the mod, and, if they're changing the contract, you have to go ahead with whatever they're telling you to do. And if you don't, there's going to be issues of non-performance. And then you're going to be on your back feet defending, as opposed to kind of being the party in control. So I wouldn't recommend that you just blatantly refuse to sign a modification. There can be serious consequences for that. Again, your factual circumstances, I don't know what the specific situation you're dealing with is. You should talk to me offline, or talk to your lawyer if you already have one offline, about what you're supposed to do in your particular circumstances to best cover your basis and preserve your claim rights. Should we include the COR in our notice to the CO? Yeah, if the COR, if you're talking about what I talked about with regard to authority, if the COR is the person that gave the order and you're giving notice to the CO that says, hey, your COR told me this, and we need to from there figure out if the CO is ratifying or denying that, and give me direction to proceed, that from someone with authority. Yeah, I think it makes sense. Why not copy the COR that gave you the original notice? I mean, probably the contracting officer, if they're responsive, is going to reach out to the COR, but might as well copy them on it. What if a contract specialist act as a CO? What authority does the contract officer, I think is what that means, specialist has? It's going to depend on the warrant of authority given to the people on your contract. I think you'd need to look into that, and see what specifically their title confers under the regs and under your contract, and what warrant they've been given. What constitutes proper notice? Well, like I said, the regulations require that you say, the date, the source, the circumstances of the order, direction, interpretation that you view as a change, and that you consider it a change. There are form letters that I've worked with clients to prepare, both in the changes notice context and, delay changes and differing site conditions and defective specifications. You probably want to have, best practices documentation wise is to have a form letter in terms of giving notice in terms of the change, and make sure that you include all of that language in there. Is there damages for IDIQ contracts when the contracting officer changes the period of performance start date by 2 months? It depends. Theoretically, there could be, depending on the clauses in your contract and how pricing is determined in your contract. Yes, there are certain circumstances where if the start date gets pushed back 2 months, that might cause changes in your labor costs or, other costs that you have, or it might be a delay in and of itself. I don't know your specific factual circumstances and why the period of performance was pushed back 2 months. And what performance was already underway at that point, what mobilization or demobilization and remobilization was required. And I don't know what clauses are in your contract. But yes, there are factual circumstances theoretically where if the period of performance is pushed back, that means that there's a change to the contract that's such that you could recover if it costs you additional money. And I think with that, we're at the end of our time, and I don't see any new questions. So like I said, if you have any further questions, you can feel free to reach out to me. Oops, not sure why I went out of full screen mode, but you can feel free to reach out to me at the information that you see on your screen. And with that, I will sign off and thank all of you for coming today. And, feel free to, or we hope to see you, I guess, at our next Fedmine Maria Panichelli webinar.
Thank you so much, Maria. Thank you, everyone. We'll be sending the slides and recording after this later this afternoon. Thank you so much.